Hello, and welcome to our webinar on the long-awaited 340B Drug Pricing Program Guidance. Today we will have 4 speakers, myself, Elizabeth Elson from Foley and Lardner, and my colleague, Anil Shankar from Foley and Lardner, as well as Carolyn Wu-Miles and Christine Farmer from Deloitte & Touche. All of us have extensive experience working with 340B covered entities on issues such as legal, compliance, transactional, and operational matters. Before we get started on our substantive agenda today, I'd like to go over a few housekeeping items. Today's program will run for 1 hour, and we will apply for 1 general CLE credit. Anyone wishing to receive credit for today's program must enter the code when announced later in the presentation during the polling question. A box to enter the code will appear on your screen for approximately 30 seconds. Everyone seeking CLE credit must enter the code in the box on their screen at that time. All New York, New Jersey, and Kansas attendees applying for CLE credit must also fill out an attorney affirmation form and write down the course code. The attorney affirmation form and a copy of today's slides can be obtained in the resource list widget at the bottom of your screen. For New York attorneys, those of you with less than 2 years of experience will not be eligible for CLE today. Completed attorney affirmation forms should be emailed to Christina Wade, cwade@foley.com. CLE certificates will be sent to eligible attendees via email in approximately 8 weeks. Questions can be submitted during the web conference by entering them in the Q&A widget, which is open on the left side of your screen. We'll answer questions at the end as time permits. As you'll see, this slide contains our agenda for our webinar. Our objectives today are to highlight key areas of the proposed 340B omnibus guidance that will likely have a significant financial and/or operational impact on covered entities. We hope this presentation will help inform your decisions on the comments you choose to submit to HRSA. Please note that because of time constraints today, we will not be able to cover all the issues discussed in the HRSA guidance, but will focus on a number of critical ones. It should be noted that there are other important areas to consider as well when you're making comments on the guidance. Please keep in mind that the guidance is just proposed at this point. Therefore, there will be an opportunity to submit comments to HRSA regarding the guidance until October 27th. Foley and Lardner is putting together a coalition of covered entities to share common concerns and strategies for developing a response, such as comments on the guidance. Details on that are provided on the upcoming event slides at the end of the slide deck. There are 2 important themes you will note throughout this presentation. One is the likely reduction in 340B savings that will occur if the guidance is finalized. And the second is the administrative expense and burden associated with implementing the guidance. Let's now turn to the 340B patient definition and some of the key changes proposed by HRSA. On your screen, you will see the current 340B patient definition. As I expect that most or all of you are familiar with this definition, I will not be reading through it, but I just wanted to highlight a couple of key points. This definition is not specifically articulated in the 340B statute, but was issued by HRSA in guidance in 1996. This current definition focuses generally on the relationship between the covered entity and the patient and the covered entity's responsibility for the patient's care. There is no additional guidance currently on how to specifically demonstrate the responsibility for care, and therefore there's currently some flexibility in how to implement compliance arrangements. It should be noted that the current definition does specifically allow for arrangements other than employment and contractual arrangements, such as referrals for consultation, as highlighted in the second bullet. Additionally, the current definition does not define or otherwise limit healthcare services that are provided other than in the last bullet you'll see on your slide, where a healthcare service would not be enough if it is just a drug for self-administration or use at home. Again, that's highlighted on your slide. Now let's turn to the proposed new patient definition. The proposed definition in the new guidance requires a closer nexus between each prescription filled with a 340B drug and the care provided by the covered entity. Patient eligibility will be on a per prescription or per order basis and must meet all the criteria to qualify. The new definition now has 6 parts as opposed to 3, which we will be walking through, as well as walking through their likely implications on covered entities. Overall, the proposed definition in the guidance would be much more difficult to manage from a compliance perspective and likely much more expensive to implement. It would also likely result in a significant reduction in 340B savings due to fewer instances of patient eligibility. This first prong is highlighted on your slide. Requires that the patient receive a healthcare service at a registered covered entity site. It should be noted that the site of service requirement used to be separate or is currently separate from the patient definition that I had shown you on the previous slide, although it has been regularly treated by HRSA in audits as part of it. It will be critical for you as covered entities to keep your registration and 340B database updated to ensure you continue to satisfy this prong if finalized. An important change to note here is that referrals to sites outside the covered entity for follow-up or specialty care is no longer supported by HRSA. Christine, do you have some additional thoughts on this?
I do. Thanks, Elizabeth. I just wanted to add one quick comment to this, noting that it has been pretty common practice for covered entities to document a referral to an outside provider within their EHR system and then render all subsequent prescriptions related to that visit as 340B eligible up to a year. For the hospitals that have been employing this practice, this proposed change has potential to have significant financial implications for the future.
Great. Thanks, Christine. So this second prong of the definition states that the individual receives a healthcare service from a healthcare provider employed by the covered entity or who is an independent contractor of the covered entity, such that the covered entity may bill for services on behalf of the provider. As noted, the definition no longer permits covered entities to provide healthcare services through other arrangements such as referrals for consultation, as we saw in the current version of the definition previously. There now must always be an employment or contractual relationship with the covered entity. One significant change that HRSA clarifies in the guidance is that having medical staff privileges or credentials at a covered entity hospital alone is not enough under this prong of the definition to satisfy the patient definition. Anil, I will now turn it over to you to speak about the second important part of this second prong of the definition, which relates to the billing requirements.
Yeah, thanks, Elizabeth. So this is a new requirement that you can see it on your screen. That the requirement is that for, not real clear if it's for employees and independent contractors or just for independent contractors, but there is this new requirement that the covered entity be able to bill for services on behalf of the provider. This is a brand new requirement. Previously, the 340B program had no real connection to billing or reimbursement, and the introduction of this connection to billing raises a lot of new issues and complexity that covered entities should really take a careful look at. It's hard to know exactly what HRSA was thinking with this, but the idea seems to be that they're trying to flesh out what used to be a general responsibility for standard that Elizabeth showed you a couple slides ago, and they're trying to make that more definite by including a proxy for what it means to be responsible for, and the proxy they've come up with is the ability to bill for services. Now, unfortunately, I'm not sure if HRSA is aware of all the complexity that raises, and it's definitely an opportunity for covered entities to inform them of what that would entail in their comments. In many cases, covered entities around the country do not bill for professional services of the individuals who are patients of the entity, and that can be for a number of reasons. You know, depending on how transactions are structured or how your relationship with your physicians are structured, it's perfectly appropriate and common and widespread for physician groups to bill for their own services. And in fact, in some states would have robust corporate practice of medicine doctrines. The ability to bill for services, professional services, is limited just to physicians. So hospitals actually can't, by law, bill for those physician services.
Great. Thanks, Sunil. Okay, the next prong of the definition includes a couple important points. First, the drug must be prescribed as a result of the healthcare service from the healthcare provider that's either employed or contracted by the covered entity. Carolyn, I think you have some additional thoughts on this that you'd like to share, please.
Yes, thanks, Elizabeth. This is Carolyn Wu Miles with Deloitte & Touche, and thank you very much for the opportunity today to speak with this great group of attendees. As Elizabeth mentioned, focusing in on this third prong, there's been a lot of discussion and debate within the 340B community for several years around the exclusion or inclusion of infusion services. And so I think, on this slide here, this is HRSA's attempt to further clarify and add some more language around their opinions around when infusion drugs do not qualify under the patient definition. So HRSA's position and clarification is really that the 340B use with infusion drugs would not qualify under the 340B program unless the infusion order was written by an eligible hospital provider and as a result of another quote-unquote healthcare service that is being provided at a covered entity site that is registered for the 340B program. So I think that statement really covers the two previous prongs and this third prong that Christine and Anil went over. So in this scenario, what HRSA is saying is that, or recommending, is that community providers who do not meet, the criteria that I laid out in terms of this proposed patient definition, where the provider is not employed by the covered entity or is not an independent contractor of the covered entity and unable to bill for the services, those infusion drugs in this scenario would no longer qualify for 340B pricing. Given all the discussion in the industry over the years, we've seen situations from an operational perspective where eligible healthcare providers within the infusion setting, certain providers have felt comfortable rewriting prescriptions and assuming the care for the patient during the infusion services that are being provided. We've also seen infusion centers where they have employed eligible mid-level practitioners and medical directors where it's within their scope of practice to provide that on-site oversight of physicians or of patients in the infusion setting. So I think, these are all things that need to be kind of further discussed given these changes around the proposed patient definition. And I'll hand it back to Elizabeth.
Thanks, Carolyn. Just a quick point to add, and I apologize if you'd already stated this, but I think something that's interesting to note that I had spoken to earlier was previously the limit on the use of a drug alone with respect to subsequent self-administration or home setting, and by eliminating the infusions as an appropriate healthcare service here, they've clearly significantly narrowed that exception, and we certainly believe that an infusion, as Carolyn was talking about, is a healthcare treatment and a billable service, and should be regarded as one in this patient definition. And certainly, as you're considering your comments to prepare and submit to HRSA, we assume that this is a significant area that should be commented on. Okay, I will now go to the fourth prong of the new definition, which likely looks very familiar to you all. This is the requirement that an individual receives a healthcare service that is consistent with the covered entity scope of grant, project, or contract. This is actually almost the same as the previous one, and it only applies to hospitals. It does not apply to hospitals. It applies to FQHCs and lookalikes and other grantees. And the only time it would apply to hospitals is if they have clinics that qualify them for their status under 340B based on a certain type of grant. And it's generally consistent with the current definition and would require grantees that it applies to understand and monitor the scope of their qualifying grants to ensure they comply with this prong of the definition. Now moving on to the fifth prong of the definition, and this is a really important prong and one that I think has some very significant impact on covered entities and also likely an area that will be one for comment to HRSA. So this new definition, as you can see on the screen, requires the patient to be an outpatient when the drug is ordered or prescribed. Just a quick note here that I won't get into in detail, but it should be noted there's actually a discrepancy in the language in HRSA's summary or preamble wording at the beginning of the guidance versus this wording that's on the screen that comes from the specific guidance provision at the end, and it may be important to keep in mind as you think about your comments. The proposed definition would effectively prevent hospitals from filling discharge prescriptions at their pharmacies or at contract pharmacies using 340B drugs for patients that were inpatient. This would effectively limit the utilization of contract pharmacy purchasing. So what the HRSA has achieved here would effectively be a limit in contract pharmacy purchasing without actually putting something in the guidance that limits the number of contract pharmacies, for instance, that 340B covered entities are allowed to contract with. It's additionally very important to note that the definition states now that a patient's outpatient classification is based on the status of the patient when billed to his or her payer. So, as an example, if a patient was treated as an outpatient and later admitted as an inpatient, and the services were all billed together as inpatient services, for example, under the Medicare 3-day stay or 72-hour rule, the drugs dispensed while the patient was an outpatient before admission would no longer be able to be purchased at the 340B price. And this is significantly different than current practice at hospitals, where there are often guidelines established for determining patient status at the time the drug is dispensed. So, for instance, if a covered entity can dispense under current guidelines 340B drugs while the patient is in their outpatient status, even if they end up eventually admitted as an inpatient. And that would change under this. And Carolyn, do you have some additional thoughts on that?
Yes, thanks, Elizabeth. I did just want to emphasize and concur with what Elizabeth and Neil have said around this addition of billing status as kind of a new component to the proposed patient definition. I think this is HRSA's attempt to add some further clarification or delineation around eligible drugs. We're seeing this, in addition to historically, just echoing what Elizabeth and Anil said, prior it was focused on patient status at the time the drug was dispensed. And now we're seeing language here where it's tying the eligibility of the prescription to billing requirements. So billing status in terms of when you would bill the patient or the payer for an outpatient service. So what I think we're going to see happening is more discussions starting to happen with your billing folks, with your HIM department, to really flow this out and see what this means kind of end to end. Because, as we all know, the billing piece happens towards the end, and it's usually, prior to a bill or a claim going out the door. So the ability to track, billing status is probably going to those discussions need to happen earlier, probably, and we need to incorporate HIM more into the discussions. Let's see here. I think I wanted to make another point in addition to just getting more savvy around payer billing rules. I think I also wanted to talk about historically clean areas, so areas within, hospital covered entity clinics or departments of the hospital, which have historically been quote-unquote clean areas that have only seen 100% outpatients, such as infusion centers or outpatient surgery centers. So historically, those clean areas have purchased all their drugs on 340B. With this change and tying this to billing status, these clean areas may need to implement a new inventory tracking system, because it may be difficult when you kind of think this through, the process flow. It may be difficult for these formerly clean areas to determine with 100% certainty that the services they furnished would ultimately be billed to all payers as outpatient services. There may be situations where a patient is admitted to the hospital as a result of complications of their outpatient services that were provided in these clean areas, and those services may be bundled into an inpatient stay and ultimately an inpatient bill that goes out the door. So I just wanted to bring up that point as well. Handing it back to you, Elizabeth.
Great, thanks, Carolyn. Thanks. I think that highlights some of the operational challenges and burdens that would be put on covered entities if this were implemented. So I'm going to turn now to the last prong of the definition, which again probably looks pretty familiar. It's very similar to the prong in the current definition that we discussed regarding maintenance of healthcare records for the patients by the covered entity. It's generally consistent and essentially just continues to require that covered entities demonstrate a responsibility for care for their 340B patients by maintaining their records. So now that we've concluded the discussion of the revised patient definition, I'm going to turn it over to Anil to start the discussion of the requirements in the proposed guidance related to Medicaid and the 340B program.
Thanks, Elizabeth. So we wanted to highlight a couple changes in the new guidance with regard to the coordination of the 340B program with Medicaid. I think this is an area where there is some confusion, and the guidance provides some or offers some new clarity, but it also leaves a lot that is still very uncertain. So as background, many of you may know, but it's helpful just to reiterate that state Medicaid programs collect rebates from drug manufacturers for drug claims that are submitted by Medicaid providers. These rebates are paid directly to the state and federal governments, not to the providers. But there are requirements to ensure that 340B drugs are not, that when a covered entity purchases a 340B drug, that drug is not also the basis for a Medicaid rebate. It's called the duplicate discount prohibition. The 340B statute references the definition of a covered outpatient drug using the definition that was put in the Medicaid statute for the purposes of the Medicaid drug rebate program. An abbreviated version of the definition is on this slide. Basically, 340B drugs include, covered outpatient drugs include outpatient drugs that are not provided as part of or incident to and in the same setting as one of a list of services, including inpatient services, outpatient services, physician services, etc. And the reason for this exclusion of these certain drugs is that the goal of the Medicaid drug rebate program was to ensure that manufacturers paid rebates only on what was the Medicaid prescription drug benefit and not for drugs provided through other Medicaid covered benefits such as physician services or inpatient services. However, the incorporation of this definition to the 340B program is a little bit strange because the 340B program does not only bill the Medicaid program, you can bill any payer with the drugs you purchase at 340B. So the application of this exclusion has always been a little bit strange because it's placed in the Medicaid statute and references specific Medicaid billing requirements. So the new guidance does address that issue, and it clarifies that the exclusion of certain drugs does not apply for patients whose services are billed to other payers. The exclusion only applies with respect to drugs that are billed to Medicaid. This should be a favorable interpretation for covered entities because it limits the exclusion to just Medicaid patients. So if you're getting bundled reimbursement under Medicare or for a commercial payer, you don't have to worry about this exclusion. That said, there is still a lot of uncertainty in this definition. The proposed guidance does not address what it means to be as part of or incident to or in the same setting. Those are undefined terms. And so without that guidance, it's hard to tell how covered entities can go about analyzing whether 340B drugs are available for Medicaid patients when their payments are, in fact, bundled. In addition, FQHCs in particular may want to comment and request more clarity on this rule with respect to how it applies to their Medicaid PPS rates, which are a form of bundled payment that in some cases may include drug reimbursement. The other thing to note from the guidance is that because this has built these exclusions for Medicaid bundled services that are provided as part of our Incident to other services, because it's built into the definition of covered outpatient drug, hospitals that are prohibited from using a GPO to purchase covered outpatient drugs may in fact purchase the drug in this exclusion with a GPO. So previously they would have been purchasing at WAC, but now they can move to a GPO. Christine, did you want to address some of the challenges, the operational challenges related to this?
Thanks, Anil. Yes, I think this is probably one of the most noteworthy areas for the operational implications that will result for the covered entities. A handful of things surrounding this. This is an area of change from the guidance that we previously had been given, where covered entities were instructed to reference the Social Security Act, Section 1927, which was for Medicare and the definition of covered outpatient drugs. The new guidance is proposing that we now focus on Medicaid reimbursement. So I think this is probably going to be one of the more challenging areas for covered entities to implement. Some of the challenges that will be that not all states reimburse the same. Some states reimburse on a cost basis, so this means that all of those drugs will be separately reimbursable, which would mean that they would be covered outpatient drugs. Other states reimburse off the fee schedule, which only has a finite amount of drugs that are separately reimbursable. So most of those drugs will be non-covered outpatient drugs. Another consideration is if your hospital bills patient claims to multiple state agencies, you will likely need to evaluate the drugs that are separately reimbursable on a state-by-state basis. Another thought is that if a patient comes in for a medical procedure and receives a drug pursuant to that procedure, then this drug's reimbursement is likely to be considered bundled into the total reimbursement of the procedure. Now, another patient may come in for an office visit and receive the exact same drug during that visit, but since the drug wasn't given along with the procedure, this drug can possibly be separately reimbursable. So the same drug may be bundled into one situation, then separately reimbursable in another situation. And then lastly, I wanted to mention that, as Emil said, this is only applicable to Medicaid. So drugs billed to all other payers will not have the same requirements. Therefore, some drugs that are deemed as a non-covered outpatient drug for Medicaid will be a covered outpatient drug with other payers. I have a feeling this new requirement definitely has potential to weigh quite heavily on the split billing software vendors, as they'll have to be able to appropriately split the drugs now into 4 separate buckets for accumulation. You'll need to more than likely have a GPO bucket, a WAC, a 340B covered outpatient bucket, as well as now a newly added non-covered outpatient drug bucket.
Thank you. So the proposed guidance also addresses the coordination of the rebates under the Medicaid drug rebate program with the 340B program purchasing to ensure that duplicate discounts are not created. The proposed guidance largely just clarifies the current law regarding the purchasing of 340B drugs for Medicaid fee-for-service patients. So that current law is that covered entities are required to report whether they purchase 340B drugs for Medicaid patients to HRSA, so that the Medicaid billing number of the covered entity can be placed on the Medicaid exclusion file. And that is the mechanism that HRSA has developed to allow states to know that they should not claim a Medicaid rebate for those drugs. And some states also have Medicaid billing requirements that should be kept in mind as well. But where the proposed guidance does make some new headway is that it addresses for the first time the treatment of duplicate discounts for Medicaid managed care patients. Prior guidance on the duplicate discount issue did not address Medicaid managed care, and HRSA has said for a couple years now that guidance would be forthcoming, and this is it. So So since 2010, states have been able to claim Medicaid drug rebate program rebates for Medicaid managed care drug claims. A report came out yesterday from the GAO that reported that most, but not all, states are in fact claiming rebates for Medicaid managed care, and the ones that are not will likely be encouraged to do so or begin to do so in the future. So this does create the potential for a duplicate discount with regard to Medicaid managed care claims. So the takeaway from the proposed guidance on Medicaid managed care and duplicate discounts is that there's a lot of work that needs to be done. Systems are going to have to be developed to identify Medicaid managed care patients who are using 340B drugs. The guidance proposes that covered entities should have mechanisms in place to identify Medicaid managed care patients. It does not provide any detail on what those mechanisms would be. The guidance encourages the covered entities to work with state Medicaid programs and managed care plans to determine how to identify Medicaid managed care patients and the 340B claims for those patients. All of this will probably require a lot of work and coordination in order to ensure that the 340B drugs continue to be available for Medicaid managed care patients without generating a duplicate discount. Christine, do you have some thoughts on the operational challenges?
Yeah, just real quick, wanted to add that the challenge that the covered entities will face is that for hospital-owned retail pharmacies as well as contract pharmacies, they typically don't have the ability to differentiate between what plan is managed care versus a regular commercial payer. Typically, the BEN and the PCN numbers, which could potentially be a mechanism that could be utilized to differentiate between an MCO and a commercial payer, unfortunately, today that ability doesn't exist. In my experience, I have found that BEN and PCN numbers are standard across the board for a specific payer, regardless of if it's a managed care or if it's a commercial payer. So I think as this continues to move forward and if this is an area that is finalized, there will be a lot of efforts that will need to be conducted with the PBMs and the managed care organizations to work with them to identify a mechanism to differentiate the various payers.
Great. Thank you, Anil and Christine, for the information. I'm sorry. I think I went one slide too far here. There we go. For all that information on Medicaid and 340B, obviously a significant area and one that is ripe for comments as well. We'd like to turn now, focus these next few slides on some of the key program integrity provisions. As you all who have reviewed the guidance can tell, there still continues to be a significant focus consistent with what has gone on recently on program integrity and oversight of the 340B program. One important issue we wanted to focus your attention on is this new 90-day repayment window that's discussed in the guidance, where it talks about having covered entities having 90 days to work with the manufacturers on repayment when there has been 340B diversion identified. So one of the issues we see with this language is that it's unclear what is meant by identification of a violation of drug diversion. This is stated in the guidance as an expectation that this 90-day repayment window occur, but it could take longer than 90 days to quantify, and it's questionable as to whether that quantification process is part of the identification, or does the identification come before or after it's been quantified. For those of you, who are familiar with the 60-day repayment requirement under Medicare and Medicaid, it raises very similar questions. And as you know, those regulations still haven't been finalized, and there's lots of questions about what it actually means to identify. Carolyn, do you have any additional thoughts on whether this 90-day window is even realistic and feasible for covered entities?
I think it really depends on how far back the covered entity thinks that the diversion issue was happening or has been happening. Obviously, if it's a more recent event, it is easier for covered entities to gather that data and perform the necessary analysis. But I know, we've worked with covered entities where they've had more systematic type issues that go back several years. And my opinion would be in those situations it may be a little challenging to gather all the historical data and complete their analysis within this 90-day window, let alone notify the manufacturers of a proposed repayment amount and start working with the manufacturers within 90 days. So I think it really depends on how far back the diversion issue potentially goes, if it's a systematic issue versus more of a kind of a one-time oops that we found. And then I think to the second bullet here, I think many of us in the industry were hoping for some more clarity or guidance around the definition of materiality, which it appears we didn't receive that in this latest round of guidance. So more to come on that area, hopefully.
Yeah, I'll speak to that part a little bit more. Thanks, Carolyn. As Carolyn mentioned, there's absolutely no discussion or definition of materiality, and that's something a lot of us were looking for because in the current recertification language that the covered entities have to complete annually, there's a requirement that they attest that they will disclose to HRSA material breaches of noncompliance. However, that's nowhere been defined, and it continues to not be defined here. They also, HRSA had previously said that they would be issuing more guidance on a self-disclosure process when a covered entity self-identifies noncompliance, and again, that has not been included in this guidance, so a lot of the questions and struggles that covered entities deal with today will remain. It should be noted the guidance does actually acknowledge the ability of covered entities to use the credit rebuild process for errors made, for instance, in the past 30 days. However, in those discussions, it's not clear if those errors actually need to be disclosed to HRSA as well. There's some suggestions in various areas of the guidance that there's no materiality requirement, and that all instances of diversion, even if isolated or minimal in amount or scope, would need to be reported to HRSA, even small ones that could be corrected with the manufacturer in a normal course of business. And this certainly doesn't seem like what HRSA intended. They have a very small staff there, and this seems very onerous on covered entities and on HRSA. And if they can be worked out with manufacturers, it would seem there should be a materiality component. So again, a very important area to consider in your comment submission. Going on to the next slide regarding some key program integrity provisions, there is a new requirement that has not been present in previous guidance from HRSA that requires covered entities to maintain auditable records for at least 5 years. This requirement will apply to child sites and contract pharmacies of the covered entities as well, and it can be extended longer if HRSA identifies a pattern of noncompliance. It also applies an additional 5 years after the termination of a contract pharmacy arrangement. One interesting point I noticed in reading HRSA's statements about this is that HRSA specifies that a covered entity's failure to provide a patient's or a prescription's records would result in a presumption by HRSA that there has been diversion. So that's obviously a concern as well. Previously, the only record retention provision was found in the manufacturer's guidelines on their audits, and that included a 3-year record retention, and so that effectively looks like it would be gone if this were finalized, and any related look-back arguments on that 3-year may end up being converted to 5 years. 5 years may become the standard, but again, that's not something that's specified. A look-back period for self-identified noncompliance, for instance, is another area that has not been clarified in this guidance. Christine, do you have any additional thoughts on some of the challenges and considerations for covered entities related to record retention?
Yeah, just a couple of areas and thoughts that had first popped into my mind that you definitely want to consider if you're potentially, at least from the record retention perspective, if you're changing drug wholesalers, any changes occurring with your split billing software vendor, or even your EHR systems. You'll definitely want to ensure that you're retaining records when you sunset those systems and that you have access to those records. I know that throughout my experiences with other hospitals, I know that sometimes they're very challenged to retain their information for even a couple of years, let alone 5 years. So keeping in mind that you will need to have the ability to access this information for, like I said, a minimum of 5 years. And another consideration is I know that some of the EHR systems will purge their data after a certain period of time. So if there's an ability to adjust those settings to retain the data longer, if not, then again, making sure that you're able to readily access the information and that it won't be too difficult if you are in the throes of an audit and needing to obtain this information.
Yeah, I'll cover this last bullet here on this slide about contract pharmacies. The proposed guidance does not contain, a wealth of new requirements related to arrangements with contract pharmacies, but it does build upon the guidance that was put out in 2010. And it seems as if though HRSA's real point of emphasis with regard to those contract pharmacy arrangements was to emphasize the importance for covered entities to have adequate oversight and compliance monitoring of drugs dispensed through their contract pharmacy arrangements. And there are several statements in the discussion of the rule about how they view contract pharmacies as areas of potential risk for noncompliance, and that no doubt follows from some of the government, I think it's the OIG publications that have come out alleging that covered entities have inadequate oversight of their contract pharmacies. So in the guidance, HRSA reemphasizes its expectation that covered entities conduct annual independent audits of contract pharmacies, and that they also conduct quarterly monitoring of contract pharmacies for each contract pharmacy location. So the ability for the covered entity to have oversight and monitoring capabilities of the contract pharmacy is going to be essential going forward. I would recommend that covered entities do take a look at their arrangements. The new guidance does not necessarily require revisions to the terms, but it does ensure that a process be worked out between the contract pharmacy and the covered entity to demonstrate that the covered entity has the ability to oversee and monitor what's going on at the contract pharmacy in terms of the dispensing of the 340B drugs purchased by the covered entity, so that the covered entity can demonstrate that capability to HRSA in the event of an audit. Also, the proposed rule clarifies HRSA's ability to remove contract pharmacies from participation in 340B if there's a pattern of egregious behavior. And it also contains a new requirement that the covered entity be the one that submits the registration of the contract pharmacy. Previously, and in practice, I think a lot of times that was done by the contract pharmacy.
Thanks, Anil. So this last slide we have on this section on program integrity is just a quick highlights of some of the key points. Most of the HRSA and manufacturer audit discussion of the proposed guidance is consistent with the current guidelines and generally just serves as a summary of what that existing guidance is. But it should be noted that where HRSA discusses the notice and hearing process that will be afforded to covered entities, that's solely based on paper submissions without a real hearing as we think of when we hear the word normally. It also should be noted that the guidance includes several examples that are worth looking at of what constitutes reasonable cause for a manufacturer to audit a covered entity, and one particularly noteworthy example is that a covered entity's failure to respond to manufacturer questions could constitute good cause for a manufacturer audit. Finally, I just wanted to note that that the guidance does not provide any formal appeal process if the covered entity disputes a finding that's issued by HRSA in their final audit report. And so I think that's something to keep in mind and consider as you're doing your comments as well. Christine, would you like to make some additional comments about these audits?
Thanks. Yeah, actually I have a handful of things to comment on this slide. First is I've conducted a couple of manufacturer audits in the past, and I've definitely learned that when you receive any type of correspondence from manufacturers, it is definitely prudent to be responsive in a timely manner. If you aren't, I think that you may find yourself the target of a manufacturer audit, and definitely not an ideal scenario to be in. These audits can be very timely, they're expensive, and very demanding. Another thing I was thinking about is some areas that HRSA auditors could possibly start auditing for today. One of the areas being, which I've actually already seen them auditing for, is the requirement that there be an association to the visit and the drug being prescribed. So I've seen that quite a bit happening for maybe about the last year. I haven't seen consistency throughout the auditors, so not all have been auditing for this component, but I have seen many, and I've seen this identified as findings for various covered entities. Another area that could possibly be audited for, which may not be enforced, but it could possibly be audited, is the requirements surrounding the topic that we already discussed about the infusion centers and reverse referral relationships. So this could be another area. It's been a pretty hot topic for the past year or two, so another area that they could be looking for. Also in the past, I've worked with some hospitals that have been in a GPO prohibition disclosure situation. And after the hospital has issued their notification to the manufacturers, some of the manufacturers have come back requesting additional evaluation of the potential repayment as far back as the problem existed. And just wanted to add that reading through the proposed guidance, it looks like clarity is being offered on the look-back period for the GPO violation, and it's proposing that when performing an analysis, if you find yourself in this situation, is that you go back to February 7, 2013, which is when the original notification was issued from HRSA about the GPO prohibition. And then also wanted to add, just thinking about some challenges that covered entities could experience with their accumulators. And one that I already alluded to was the potential for the need of hospital pharmacies to account for all of the drugs being dispensed in the various buckets. So currently today, there are typically 3 buckets in each of your accumulators, being a WAC bucket, a 340B, and a GPO, with possibly a 4th bucket being required, which would be the non-covered outpatient drugs. So you'd find your inpatients landing in the GPO bucket, your 340B covered outpatient drugs now being in their own separate bucket, and then for all of the outpatients whose drugs did not qualify as 340B eligible, that may be classified as the 4th bucket. And then lastly, a violation of the diversion prohibition can occur if a covered entity isn't properly accumulating the 340B drugs, the 340B drug inventory. And as noted in the guidance, HRSA is still encouraging manufacturers and covered entities to work together and correct any errors that are found through the credit and rebuild process. Unfortunately, I'm sure as many of the covered entities are very much aware that these types of discrepancies are relatively common occurrence in the 340B program. And if a covered entity isn't regularly monitoring their program and their accumulators, they possibly won't notice that these issues exist, and they may find themselves in a disclosure situation because the issue has perpetuated for so long that a credit rebuild won't be possible. So with all of that, I would say the biggest piece of advice I'd like to leave you with, which is also a theme throughout this guidance, is to definitely keep your finger on the pulse by continuously auditing and monitoring your programs.
Thanks, Christine. Anil's now going to discuss briefly the status of the proposed guidance.
Great, thanks. So this is a very technical legal issue, but it's of importance, and covered entities out there should be keeping these issues in mind when they're evaluating the proposed guidance. HRSA has issued this proposed document as what it says its intent is to assist 340B covered entities and drug manufacturers in complying with the statute, meaning the 340B statute. So it's classifying this document as interpretive guidance and not as a regulation or a substantive piece of rulemaking. And the phrasing and this description of what it's doing was certainly carefully drafted by HRSA and HRSA's attorneys to support the argument that the rule is not a substantive rulemaking that creates new rights or obligations that are not authorized by the statute. And this is because last year a court ruled in litigation brought by some of the pharmaceutical companies that HRSA lacked authority to issue substantive regulations regarding the 340B statute except in certain discrete areas. So HRSA is now proceeding with this document as an interpretive statement, and it's currently defending its ability to issue interpretive statements in court. And so what does this mean? What is the distinction between an interpretive statement and a substantive rulemaking? The difference is that the interpretive statement clarifies obligations that are established by the 340B statute rather than creating its own set of obligations. Now, in practice, interpretive statements are likely to be given deference by a court of law, and there may be, in practice, be very little difference or meaningful impact between a interpretive guidance and a substantive regulation. However, this conclusion has not yet been adjudicated, and it's still a live issue. So in drafting your comments, you may wish to consider areas where the obligations described in the guidance do seem, on any reasonable reading, to exceed what could be defended as an interpretation of the statute, keeping in mind that HRSA does not have the authority to create its own obligations. It only has authority to issue clarifying statements of what is required by the statute itself. And you also should be aware of the potential for HRSA to apply some of the provisions described in the guidance even before it is finalized. Now, the guidance is drafted as a proposal, and HRSA is soliciting comments, so there does not appear to be an attempt to issue this as a description of HRSA's current policies. However, because it's just an interpretation of what the statute requires, in some cases it's not clear whether the proposal is a new interpretation or just a clarification of a current interpretation or just a restatement of a current interpretation. And as a result, there's this kind of legal gray area where you don't know whether the stuff in the document is going to be applied by HRSA or HRSA's auditors. And we just spoke about some of the areas that might including the infusions, because they could do so on the theory that all they're doing is interpreting what the statute says, and they have some flexibility to change their interpretations over time. So it's also the case, and this is something you could mention in your comments, is that because this is not being issued as a substantive rulemaking, HRSA has not done a regulatory impact study of the impact of the rule, and as a result it falls to covered entities to inform HRSA and inform the government of what the potential impact of the rules would be on their operations and on their finances. So to the extent you can build a detailed case about adverse costs, that's something that the government may be interested in hearing as it finalizes this rule. And lastly, I want to, you already did it. Lastly, I want to highlight just a couple areas where HRSA has specifically requested comments. There are a few of these areas listed in the preamble. And I want to make the point that when you're submitting comments, the government really does appreciate it if you can identify a constructive alternative. You know, it's one thing to get a litany of comments that say this is unworkable, please fix it. But they do appreciate proposals, and to the extent you have a specific proposal that would be more favorable to your organizations, it can be very helpful to inform the government of that and potentially have that adopted. So some of the areas where they've requested information is they've requested alternatives to how off-site hospital outpatient facilities or clinics may demonstrate 340B eligibility. And this is an area that currently they use the Medicare cost report test, which has led to significant delays. So alternatives would be greatly appreciated in the covered entity community. Other issues involve the ADAP, or the use of the Medicaid exclusions file. And I spoke earlier about the need for approaches involving Medicaid managed care, as well as the information required to demonstrate compliance on re-enrolling after you've been removed from the 340B program.
Okay. Now it's time for those of you who need CLE credit to enter this code. The code you need to enter on your screen is 3286B, as in boy. Again, 3286B. And one final time, please make sure to enter it. 3286B. Thank you. So, quick point about some upcoming events. As I mentioned earlier, there's going to be a kickoff call we're doing with covered entities this Thursday morning. If you're interested, my contact information is on the screen. There's also a Business of Personalized Medicine Summit coming up. Information's on the slide for that. As a reminder, there'll be a brief survey for you to take about this webinar. At the end, it'll pop up automatically, so we'd appreciate it if you have time to take that as well. I know we only have a few minutes left, but I think we have received some questions from the audience, so we'll try to cover a couple of those at this time.
Yeah, we received a couple good questions about the billing requirement in the patient definition. Let me see if I can get it up on the screen. I think it's the second one. Here you go. Yes, we received a couple good questions about this. This is an area of a lot of confusion, and it's specifically about this requirement that the covered entity may bill for services on behalf of the provider. So we received two comments, and I have heard these kind of arguments out there as well. These are areas where folks are looking at. One question is, what does it mean for may bill? Arguably, you can make the case that even though a covered entity does not bill for provider services, they could. And I think the issue, the nub of the matter there is putting some meat on what it means that you could. Obviously, everybody could bill for services if the world were different and if the corporate practice of medicine didn't exist, et cetera. But it really does speak to the confusion at the heart of what HRSA is trying to do. I mean, they're trying to tie the definition of patient to individuals the hospital has some responsibility for, and they're using billing as a proxy for responsibility. But there's just too much complexity in billing to really be a good proxy for that purpose. And if you could come up with an alternative way to say, well, we could bill for them because these are really our patients served in our facility, and maybe your facility owns the physician group or has a very close relationship with the physician group, et cetera. If you can make that case, I think it's something that is worth clarifying and requesting that HRSA clarify in the final rule. The other issue is what services are we talking about? The rule just says may bill for services on behalf of the provider. There are potential arguments that could mean if the hospital covered entity, for example, could bill a technical component of a service, but have the physicians bill their own professional component, maybe that would qualify. I will say that for both of these arguments, the may bill and the services on behalf of, I think it's not clear, and it does require clarification. But these are exactly the right kinds of questions to be thinking about and to be asking the HRSA to clarify in its final rule.
Thanks, Anela. Christine.
Yeah, there were a couple of questions in there about the fourth bucket, and this is just an area that I'm surmising will be a new requirement as we move forward, but inquiring about what that fourth bucket would look like. So like I mentioned, right now everyone's very familiar with the three buckets, the 340B, the GPO, and the WAC, and inquiries about are we able to potentially put the non-covered outpatient drugs in the GPO bucket. And yes, while you will be purchasing those drugs at GPO, I think the differentiator between the two, the need for the fourth bucket, would be that everything that's in your true GPO bucket would be drugs that were administered to hospital inpatients. That fourth bucket would be the drugs that were administered to outpatients, but the drugs were classified as non-covered. So I think it's more for an auditing perspective so that you weren't looking in your GPO bucket and saying, uh-oh, I have outpatient drugs that accumulated to my GPO account. So, of course, which would be a GPO violation if you weren't taking into consideration that it was a non-covered drug. So I think it's more to make the process a little bit more clean. So, of course, we'll see how everything plays out as we continue to move forward in the process, but maybe just an area to possibly simplify the process.
Thanks, Christine. I think we're just about out of time. We got one other question I thought I'd try to respond to quickly here about the absence of the material breach clarification and whether that could mean that HRSA is eliminating the option for a covered entity to determine their own material breach thresholds and that all instances of noncompliance must be reported no matter how small. I do actually think that the way the wording in the guidance is, proposed guidance is drafted, that could be what that means. They a few times talk about any violation needing to be reported. That does not seem consistent with the attestation language, so I do think it's a very important area to comment on and provide some either alternatives or ask for clarification, because I do think that's a possible interpretation. So I think at this point we're going to need to wrap up. To the extent that other questions were submitted from covered entities, I believe we can get your information and do our best to get back to you electronically. And at this time we will be concluding the program. And thank you very much for participating, and we look forward to speaking to you all soon.